coastal erosion is one of the most important issues that I feel that this state is confronting and will confront in the future. So I feel adamant about what has been done in these lawsuits and what will be done in the future. First, I have to say, though, that I am not here representing the state of Louisiana. The state has their own lawyers. I represent the parishes in this litigation, and the parishes have filed a lawsuit which the law allows them to do. I think the first thing I'd like to do is kind of give you a little history of what got us here today. In 1972, NOAA, the National Oceanic Atmospheric Administration, 1972, adopted the Federal Coastal Zone Management Act. And NOAA came to these states, most importantly Louisiana, and said, look, we want you involved. We want you, this is your state, either we take it over, the federal government, or you, the state of Louisiana, do what you feel right. So they allowed Louisiana to create its own coastal zone management. And that was started in 1978. And what Louisiana was required to do by the federal government, they were required to do what's called a final environmental impact statement. It took several years to perform. It is very, very detailed. It's online. And it goes through the problems and how the problems need to be solved. Or when Louisiana's legislature was developing the statute, they needed to take that in consideration. So for 2 years, everybody was involved. Everyone. The public, the legislature. These are the list of the industry participation and comments. As you can see, every large oil company was given the environmental impact statement and was given the actual legislation. So to say this was done behind closed doors or all companies were not aware of the new law is not true. Because they were there every step of the way. They got to comment, they got to go to lobby legislators, and they did. So what happened? Legislature being lobbied by the oil companies. Dr. Paul Tomplay was one of the co-authors of the regulations, and he was at the legislature. The language, the most critical language, some of the most critical language of the statute was hijacked. The legislature changed it and adopted what the oil companies wanted. So it went to Congress. Congress said, no, you have to go back and you have to fulfill your obligations that we told you in the federal impact statement needed to be done. Paul Tomplay got back involved, the law was changed. So the oil industry was well aware of what was occurring and what was going to be adopted. So what was adopted? So in 1980, which is the most critical year, and I'm going to keep going back to that date, because all companies had choices. It's not like they didn't make the decision to put them in the position they're in today. It was their choice, no one else's choice. They knew in 1980, this is the regulation, mineral exploration and production sites shall be cleared, revegetated, detoxified, and otherwise restored as near as practical to their original condition. The creation of underwater obstructions which adversely affect fishing or navigation shall be avoided to the maximum extent practical. They knew we're going to get some very specific decisions they made. They finished the operations in the coastal Louisiana. You have the obligation to restore the property to its original condition if you were required to get a coastal use permit and if you violated it. When did they need a permit? They needed a permit when they were causing coastal use affecting the coast. Dredging, discharging. They needed a permit. That was the law. They knew they needed a permit. So at that time, if after 1980, their activities were causing coastal problems, they needed to go to the Coastal Zone Management Statute and Office and get a permit, which is a contract. What do those contracts say? The contract says this. The contract they were supposed to get says you have to restore the property to its original condition. 99% of the lawsuit issues we filed for these parishes involved contract permits that they did not receive. They ignored the law. They were required to get a permit every time they dredged. They were required to get a permit when they were dumping toxic waste into the environment. And they were required to get a permit to restore the property to its original condition. 99% of this case, they don't exist because they didn't go, because they didn't want to have that signed contract. Also said, areas modified by surface alteration activities shall be, to the maximum extent practical, revegetated, refilled, cleaned, and restored to their pre-development condition. Any surface alterations, very clear what your requirement is as an oil company if you choose to go past 1980. Canals, which you see in riding along the coast, these canals all over the place, areas dredged for the canals shall be backfilled or otherwise restored to its pre-existing condition. That's the law. Those three parts of the regulation that I just stated to you is the law of Louisiana, and it's been in effect in 1980 and it has not changed. And all companies have not gone to the legislature to change it. They understood it. They understood their obligations. They failed to follow the law. It's that simple. Okay, so what are these lawsuits about? What got us to the point we're here for today in court? I'm going to assume nobody really knows the details of oil field operations, but when you're drilling for oil and gas in Louisiana, you produce a lot of what's called produced water. Produced water is waste. The oil companies can't make money with the waste. It has barium, chromium, radium, chlorides, seawater. I think it's about 35,000. They're pulling up water that has over 150,000 parts per million of chloride. So they have a choice. And they're producing this water. What do you do with it? Can't make money off of it. What do you do with it? The choice was, going back to 1920, to install a saltwater disposal well. They install a well, the water goes into tanks, and the water is injected down 3,000 feet, never hits the surface, never hits the marsh, and is never stored on property. Simple. These oil companies on that list were doing it. They knew the technology was there. 20s, 30s, 40s, 50s. The other option, which is the cheapest option, is to dump it overboard. The other option is to dig a hole in the ground, don't line it, dump it, and allow it to seep and leak and destroy the coast. That's the cheapest. That's what they did. What came out through discovery in the Roselle case, what we tried, is going back to the 30s, Texaco owned feed processing. So did other ones. Texaco had a saltwater disposal well on their own property. In the case we tried, they didn't have a saltwater disposal well there till 1993. 1993. So understanding the technology, understanding that they drilled a well to protect their property. On state land and other land, they chose to do so. So, I want to make it very clear what these parishes told us to do. And we took our job very seriously. They said, go out, this is the coastal zone, go out and find out if they received the proper permits or they violated the permits they obtained. So these red dots are all the wells that were drilled in the coastal zone. And we went through in detail with our experts to figure out where did they violate the law. The biggest thing that I think the public doesn't understand, or is not informed, but understand, is if an activity that was occurring prior to 1980 did not continue after 1980, the law does not apply. Let me restate that. If the oil company stops discharging, if the oil company stops dredging canal, if the oil company stops using pits prior to 1980 and doesn't continue that activity, they do not. They were aware of that. It was a choice. I have a choice to stop these activities, which their documents show they're destroying the coast. They have a choice: stop, or the regulations apply. Restore the property to its original condition when you're finished. So they were well aware and made an educated, calculated decision. Either we don't care because we don't think we're ever going to have to, probably what they thought, or we'll do it if somebody catches us. There are documents to that effect. So nobody held a gun to these oil companies' heads in 1980 and said, you keep going. And they made the choice. They put themselves in this position. They're in a position now to have to restore the coast only for real and provable damages that they caused. I'm going to go through that. So these green areas, what we call operational areas, that we determined where they failed to get a permit 99% of the time. So those are the wells being sued on. Now, let's go back. We're not suing on all the other red dots, either because the activity stopped in 1980 or they didn't need a permit. So this lawsuit is not something that these parishes took very lightly. To just go out and say, you know what, we're not going to do our research. We're just going to go out and file a lawsuit against every oil company and every well and everywhere and see if we can get some money. That's not what happened. Only these wells were sued upon, and these wells are violated. I told you about pits. It contains more contamination. It can migrate for miles. It contaminates drinking water aquifers of the state of Louisiana. In other states, they were not using this. They were using saltwater disposal wells. They had concrete lined pits in Texas. They had other lined pits in Texas, Kansas. In Louisiana, up until 1986 and beyond, this is what one of them looks like. That is oil and sludge. There's 9 out of 10 times sand on the bottom. They put hundreds and hundreds, thousands of barrels of produced water in these unlined pits throughout the coast of Louisiana. Saving money? Dump it. Free. Free. Let it migrate. Dump in the marsh. Overboard. Cheap. Cost you nothing. End of the day, we don't think, the oil company, that the state of Louisiana will force what we signed and agreed to. So I'm just going to go through. It's just examples around the state of Louisiana of what has happened There was identified over 20,000 of these across the state of Louisiana. It's now over 40,000. They were just pipe. But what does this cost? How does it affect the coastal zone? I have pictures, speak 1,000 words. So 1974, this is Crab Lake Field. The red triangles are wells. This is when the fields kind of gets developed. They're discharging produced water into these pits, which is overflowing into the marsh. By 2013, majority of the land is gone. The most important feature that I like is that's the coast. And that up top, there were no oil wells. There's still land. There's still land. So I'm going to run through these real quick. You can see this is the evidence we have. That is oil in that pit. The land is gone surrounding the pit. This is equipment that is out there today. That after they finish, they need to restore the property to its original condition. It's still there for the taxpayers to fish around, contaminations there, just everywhere along the coast. Part of this lawsuit is to get them to remove this waste so we can have a beautiful coast of Louisiana. This was the trial. This is before and after land loss that was proven to the jury. You can see where they discharge, the land is decaying, and it ends up basically with all water. Around where they discharge into the marsh, hundreds and hundreds and hundreds of thousands of barrels of produced water over the years. If you go into marsh today where the case was tried, you stick this stick in and all the clean comes up, nobody can see it. Children are fishing there. This is all over the coast of Louisiana. This is the verdict form. The jury got some things right, some things wrong. We were asking for $2.5 billion. They were reasonable. They weighed the factors. The defenses were hurricanes and the Mississippi River. The jury felt that they should pay 25%. The jury heard all of the evidence and came to this decision after finding that they violated the law. They did not receive the proper permits. A little more time. I want to also make sure that you understand what the jury heard also. There's been talk about, well, you hold them responsible. There were no laws in the past. This lawsuit is not about the laws in the past. It's about the 1980 law. However, I have to agree. There were no laws. Louisiana had laws going back to 1926. Do not pollute. Over and over again, do not pollute. You don't have a right to destroy land. You have to get a permit. You have to get written permission where you're going to discharge into this coast and into the environment. There's none. They ignored them. They ignored them then, they ignored them in 1980, and they continue to ignore them. Good fun fact, in 1946, our wildlife and fisheries had enough. They had enough. They passed a resolution and accept. The commission accepts these statements by Coastal Rouge and rules that the discharge of such waste would adversely affect the oyster and fisheries industry and would prevent or injuriously affect the growth and propagation of animal and vegetable life. And it here be resolved that the commissioner order all oil companies operating in the parishes, Cameron, Vermilion, Lafayette, Iberia, St. Martin, St. Mary, Terrebonne, Rouge, Jefferson, Blackman, St. Charles, St. Bernard, Orleans, St. John the Baptist, St. James, and St. Tammany, to seize the discharge of oil, brine, and other waste into the water of these parishes. That was in 1946. They had enough. They had studied it. What did they do? tells you that. They sued wildlife officials. Now, we're the bad guys, right? Parents, we filed a lawsuit. Well, everybody hates lawsuits. Well, when the state had enough, what did they do? The first thing they did was turn to a lawsuit. And they held up Louisiana. Finally, it went away. And the law continued to require them to get written permission. There's none in very few cases. And that's not what this lawsuit's about. Lastly, now I'm going to tell you. I want you and the public to know the law is very clear. Very clear. Every dollar awarded in this lawsuit and in every law, either by judgment or by settlement, has to be used to restore the coast consistent with the master. Not $1 that over $700 million judgment goes to lawyers, doesn't go to the parish. It goes to restore the coast of Louisiana, every dollar. Every dollar. And so the myth that it's just a money grab, that's not a money grab. It's to protect the coast and hold people accountable for violating the law. We all are held accountable. Every day. Every day. We speed, we get a ticket. So the parishes want them simply to follow the law. And I'll give you an example of how they didn't run out. Cameron Parish. Went to sit down with Cameron Parish with their local lawyer, great lawyer, Mr. Mudd, and we sat there. And he was worried. There's a lot of oil industry stuff going on in Cameron. LNG plants. They said, we don't want to really file a lawsuit. I said, don't. I hope you don't. But you need to ask them. Cameron Parish went out to these oil companies and asked them to come up with a plan. They said, we'll be back. We'll be back with a plan to solve your problems. With all the pollution and the equipment left in your parish, we're coming back. Cameron Parish waited 2 years. 2 years from the day of that conversation. Never came back. They gave Cameron Parish no choice but to file a lawsuit. Every opportunity that's given to them, no one's stopping these oil companies from going and pick up the equipment. They're just not doing it. And they're not going to, in my opinion, until they were held accountable. So everybody's like, why is it taking so long? They keep removing. And so we've been in federal court fighting for 7 years. We won that. What the claim is that since you are alleging activity that occurred during the war, then the federal officer statute ought to apply. We say no because of all kind of legal jargon checks, okay? But we already know. We won. We won at the district court level. We won at the U.S. Fifth Circuit Court level. We're then remanded back. So we're back. So there's 42 lawsuits filed. And then they applied for the cert to the U.S. Supreme Court for them to hear the U.S. Fifth Circuit's decision, which we're winning. The U.S. Supreme Court granted that. So the only issue at the U.S. Supreme Court that probably will be heard in January, there's only 11 cases left. So out of the 42 and all of these other parishes that have been filed, it really only affects 11 cases. And their argument is they tie it to a refinery because they feel under the law they can meet that requirement. So right now, only all the cases are back. There's only 11 that might end up in federal court. We have to wait for the United States Supreme Court decision. And that should happen probably hopefully tomorrow. The attorney's fees. There is no contingency fee contract. There is no contingency fee contract. The law since 1980 has not changed. The law says that the parishes, the state, and others have a right to pursue this claim. The parish has a right to pursue. It also says that the attorneys get reasonable attorney's fees that, in this case, will be after we get the verdict final. We can then go to the judge and ask for reasonable attorney's fees above and beyond this number. But right now, we never can touch this number. We have to go to a judge and ask him and prove what a reasonable attorney's fee would be. So that's how the attorney's fees do not come out of this money.
But who pays that?
The attorney's fees, the responsible party. That's been in the statute. They knew from the beginning that if they were held accountable, the reasonable attorney's fees would be on top. That hasn't been hidden. It's been out front since it happened. Next question. Great question. So the question was, who's in charge, it's state agency, who's in charge of requiring these permits? And I think I'll say what you said, is who failed to do their job, okay? In my opinion, I'll just state the facts and let you do your job, okay? The Coastal Zone Management Office of DNR has been in charge since 1980, okay? Since the beginning of time, going back to the 20s and 30s, and still today, Louisiana, like many other states, and so does the Fed, is self-reporting. There's no way. We've had, I've taken depositions, we had 4 inspectors for the Coastal Zone Management for 20 years because of budget issues. That's why it's self-reporting. All companies are responsible to go get the permit. There's no way any agency, even today, could follow them around and say, you need this permit. They have the responsibility. They understand when they operate in Louisiana, this is the law is going to apply, and you need to follow it. And your responsibility is to go get a permit. Build a house. Great example. I actually told the jury that you have an obligation we all have an obligation to get a permit. What happens when we don't? We're violating the law. So just like every one of you today has an obligation to get building permits and other permits, these all companies knew they needed a permit. They didn't want to do it. And, look, we all know politics in Louisiana. And there was a statement made by someone, not me, at trial. Look, sins of the past. And, that's why I give so much credibility and tapping the back to these parishes for finally someone has enough guts to stand up and apply the law. Nobody's special in this state. If we do something wrong, you stand up, you take responsibility, and you fix it. And we teach our kids that. Make a mess, clean it up. And so it happens. We wanted to make it very, we want to make it very clear, I mean, the parishes only have a right to enforce the coastal zone management law. So, you know, the parishes were adamant, we don't want to follow something that doesn't exist, and we're not gonna, so the only law that the parishes have the power to enforce is the coastal zone management. I'm not an expert but it's my understanding that only in the past, in addition to getting a coastal use permit to do these activities, in some circumstances, like dredging canals, they also had to get a full core permit. But that's a federal issue. We're suing over the state permits, not the core permits.
A question. Are the companies and individuals, whomever, cleaning up their wells today? And if not, is there any enforcement going on?
They're not. The enforcement is these lawsuits. So that's why I made it my mission, 12 years ago, I was not gonna stop until we achieve the goal. And the goal is for them to clean up their mess. Because of one reason, I wanna make this very clear, and I'll get back to what is these lawsuits, their claim of running business out. You think about it, if any businessman, until we relieve the liability that was caused by Big All who's gone, and the prices determine if they're gonna come back, if we can't relieve that liability, how can we bring in new business? It's like, who's gonna go, today you can't even get a mortgage without an environmental study. So they can't go build plants. They can't go operate because they don't want to be held responsible for something they didn't do. So my opinion is, which I strive for, and I've talked to independent oil companies all over the country is, hey, let's get rid of the liability and come drill, baby, drill. That's what the state needs. Nobody's fighting oil companies to come in and be responsible and put the jobs back. But they will not come unless somebody takes responsibility of the mess that's in our coast. So when these lawsuits are over, I think it's going to be an economic boom for the state of Louisiana. I think you're going to have more oil companies that want to do the right thing to come back and drill where there's still oil to be drilled.
Well, it sounds like though, if there's no enforcement, we're gonna just be continuing a problem that repeats what happened before. I mean, could the state not enforce this? I mean, permitting, clean up, if it was so inclined?
They do that. I mean, it's ongoing. The coastal zone management commissioner and the Office of Conservation Commissioner. I mean, they get stuff every day where they make people go plug and abandon wells, they make people clean up. But the issue of if the permit, coastal zone permit was violated, that's what these lawsuits are about. So we're now in court. So we're solving it in court because that system didn't work. And that's why we're here today. Yes, sir.
Speaking to what he's asking about the enforcement, I heard you correctly. I'm asking about oil enforcement of the decision of the state. So I heard you correctly. The oil companies were doing the right thing, setting up the cement reservoirs and whatnot in other states. Was there culture that was known that, hey, it's
It's, the question was, these oil companies were doing cement line pits in other states and discharging below. What happened in Louisiana basically was it a culture issue? Because we had the laws, right? Now I went through the law. And there was a culture. The culture was when there are critical issues that occur in the state of Louisiana, it's cheaper for them to play politics than to actually do the right thing. So what happened? This is a couple of examples. 1986, law changes. State of Louisiana says we're tired of dealing with these pits. Close them. Commissioner took his deposition. Said, how did you become commissioner? I don't know. I said, well, where did you work before? This is the most critical part of the state of Louisiana. You have to close all these pits. Well, I worked for Amoco for 30 years. I said, where? Hackberry. I said, any environmental experience? None. Know anything about groundwater contamination? None. I said, did you require any of these oil companies before this check mark in compliance was done? Did you require them to send you the data and review the information? No. I said, well, how many inspectors did you have and hire to go make sure all of this was done properly? I had 4. I wouldn't call them inspectors. I'd call them Pizza Hut delivery drivers. So the culture was that when this critical time, every time almost, I can give you examples, it was a cheaper way to do it, right? Yes, sir.
It's a state law that we're talking about. It sounds like it's the parishes who are doing the law through. Why is it the state attorney general responsible rather than the parish attorneys?
So she is, but so the statute allows, okay, the attorney general, the local coastal zone management officers, a local DA, and the DNR. Those are the 4 that can file. It doesn't say who has one. Parish is 5, 12 years ago. Since then, the attorney general of this state has intervened and is applying the law. In my opinion, I'm not here to speak on her behalf, and enforcing the law. They participated in this trial. So did DNR, Governor Landry. So again, not here speaking for them, but they participated. They are at it. I mean, the Attorney General's office will argue at the United States Supreme Court. So everybody, in my opinion, it's just my opinion, is involved and wants to see that the law is applied so future generations and taxpayers don't have to deal with this problem. Because if we just let industry off, oil and gas industry, who's left with the problem? Look at our orphan well program. It's broke. So everybody's involved now, sir.
So 2 former Joint Chiefs filed a brief worrying that the lawsuits might hamper public-private partnership. I'm curious what your response is, and 2, do you think that influenced the court's decision to grant cert?
Say it again, I'm sorry. I missed what they filed saying.
They filed a brief basically saying that the lawsuits, should you win, could hamper the public-private partnership. I'm just curious what your response is, and if you think that influenced the court's decision to grant cert.
I hope not. They also argued that there was a split in circuits. So I'm hoping that's part. But to get to your point, we can't ignore the law, right? And what we know through the history and taking depositions, even of Lamoga's head person, there has been no proof, 0. And every time someone states it, I say, where's the evidence? These lawsuits are not running these oil companies out of the state of Louisiana. If the price is right, they come. And I've had cases for people, and they're banging on the door while the lawsuit's pending. The parish with the most lawsuits is Cameron, where all the LNG plants being built. So it's easy to say something, and I can say anything I want to, but I don't. I feel someone has to have the evidence and proof. So I'm hoping just making a statement can't make the United States Supreme Court, our precious court, just because someone makes a statement without any evidence. And I promise you, there's no evidence in that brief. get to that.
What do you make of the fact that the Supreme Court took the case up after this case has been settled twice, right, beforehand, so they're revisiting issues that's been litigated twice from the Supreme Court?
So the argument, after we won the US Fifth Circuit, and they even asked for en banc, which means all US Fifth Circuit judges vote. We won that too. So you go to a 3-judge panel, and then they ask for all of them. We won that also. There was an argument to get to the US Supreme Court. There were split circuits. So our circuit is the US Fifth Circuit. Way back with the federal officer statute, there was a standard. It was called the Latchley case. And that was the latest US Supreme Court decision that you need the law changed. I'll just put it that way in a simple way. Okay? New York, they're saying, is not applying the new standard. They're applying the old standard. No one has taken a writ to the Supreme Court. So if you're asking my opinion, I think this is to settle that. Could be totally wrong. But there is a split in circuits. I can't deny it.
Have they challenged the actual verdict itself?
We're not there yet. So we agreed, we were going back, we had a hearing date to go back to get input on this judgment. And that's when the Supreme Court granted the writ. So rather than move forward, we all agreed, have the hearing in January, hopefully get a decision in April and move forward.
They haven't had to put them on, you know, or anything?
Not yet. There's no final judgment.
And then maybe the last question here.
If there's no stipulation that a law I'm going to ask you about is not applied, is there any reason or concern about the mere existence of Part 4, which is the revised statute, Title 30, Section 51, a prescription of penalties, which can be asserted at any stage of the litigation? Is there any reason for concern about the mere existence about that?
No, I think we pursued the claim, which is the only portion of the statute that where the parish is, and it's actually all of them, it actually says in D that you can seek injunction, you could pursue a lawsuit for damages, you could pursue a lawsuit to restore the property original condition. So by law, in my opinion, that's really the only viable statute that this lawsuit was brought on.